23022140. That's people of the state of Michigan versus Charles Trainer. Will the parties please introduce themselves for the record?
Marshall, on behalf of the people.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Mr. Trainer. He is standing to my right.
And sir, you are Charles Trainer?
Yes, sir.
All right. This is the time set for preliminary examination. It's my understanding that we are going to be running the preliminary examination today. Are there any pretrial matters, preliminary matters to come to the court's attention before we get started today, Mr. Marshall?
I don't believe so, Your Honor.
Mr. Abbott?
One for the defense.
All right. There's a motion for sequestration order, obviously, so any potential witnesses shouldn't be in the courtroom to hear another witness testify. I'll leave it to counsel to bring that to my attention if anybody's in here that should not be in here, okay?
It's just one officer involved, Your Honor.
All right.
So
Your Honor, Ms. Culpepper is a witness, and I don't anticipate right now calling her, but she's potentially.
right. So ma'am, as a potential witness, I'm going to sequester you. So I'm going to have you be out of the courtroom. You shouldn't see what another witness has to testify to. It's both a protection for the court and yourself. All right. So I'm going to have you sequestered out of the courtroom, and Mr. Marshall, you may call your first witness. All right, officer, you can come right up here.
and Your Honor, the people call Officer Forbes.
Okay, Officer Forbes, you can come up here, and I'll have you have to state your. I don't know if you can state your first name and your last name for the record.
Yes, it's Robert Forbes,
Okay.
ROBERT FORBIS.
All right, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, have a seat. The microphone is for recording purposes. I'd have you project to the back and let me know if the fan's bothering you. We can turn that off. All right. Mr. Marshall, you may proceed.
Officer Forbes, where are you employed?
Lansing Police.
In what capacity?
I'm currently assigned to Uniform Patrol.
And what were your previous duties? Did you have any other previous duties?
Yes. From 2018 to 2021, that 3 years I was with the Violent Crime Impact Team.
And what's that?
It's commonly referred to as VCI. It's a blend of plainclothes surveillance and marked patrol units with the overarching goal of reducing violent crime in Greater Lansing area.
And were you employed in your current capacity on May 8th of 2023?
Yes.
Or the 7th.
Yes.
And while you were employed in that capacity, were in marked patrol vehicle, were you conducting regular patrol near the St. Therese School on that day?
Yes.
And is that in the city of Lansing,
Yes.
County of Ingham?
Yes.
And what did you observe that day while in that area near the school?
I remember this day very, very well. It was a very nice Michigan summer day. It was sunny and very nice. And I was just driving, moving patrol, regular just patrol. This particular area has had several complaints recently of weapons related incidents, quality of life issues. And so I was just cruising through the area essentially. And I saw that there was, at my first glance was that there was a family playing at the park.
And did you stop and observe that, or what did you do at that point?
So to just try to describe it, Judge, the school has at least two entrances. One entrance is off of Randolph. The other entrance is off of Turner. And I came from Randolph and was driving essentially almost in a U around the area to the Turner Street entrance exit. And in that became, in my view, the playground and in the general area. And that's how this came into my view as I was driving through right in front of me.
And what did you see that that caught your attention?
The first thing that caught my attention, really, this started off as not suspicious. I saw a man and a woman and a couple of young kids on the playground, and it looked like a beautiful day to be in a Lansing Park. And everything changed when Mr. Trainer saw my patrol vehicle getting closer, and I saw him, and his demeanor changed from playing with the kids and the female to looking very anxious. And I saw that he made a retention touch to the right side of his waistband.
What is a retention touch?
So a retention touch is what it is an indicator that someone is armed. And we learned all about this at a training that was hosted by the ATF when I was in the VCI team.
So you have past training experience in observing and learning what a retention touch is,
Yes,
and you observed the defendant do that on this day?
yes, I did. And furthermore, once that happened, combined with his demeanor change from playing to appearing nervous and anxious, and combined with a retention touch, it allowed me to now, as I was moving forward, get closer to him. And I saw that there was a very distinct bulge protruding through his black t-shirt, consistent with the handle of a firearm based on my training experience.
And what did you do at that point?
At that point, I remained in my patrol vehicle, and it made it, my sense of suspicion was continuing to rise, that he was carrying an illegal firearm, because as I got closer, he walked from near the playground equipment to a nearby I don't remember if it was a picnic table, Judge, or a bench. I think it was a picnic table, but he sat down at the picnic table and put his arm on the item that was protruding, that I suspected was a firearm. In other words, trying to further conceal what I suspected was a firearm in the behavior change.
And did you make contact with him at that point, or?
Yes, eventually I made contact with him. I did not exit my patrol vehicle. I had my windows down, and I just pulled up relatively close to him, and told him flat out, hey, do you have a CPL? Because at that point I was convinced that he was armed. And his response was that she did, and indicating to the female that was with him at the park. Meaning to me, if she does, he's indicating that she does and not himself,
Not.
pinpointing to me he is armed illegally.
And what, at that point, did you specifically ask him, or what did you do at that point?
Yes, at that point I got out of my vehicle and directed the conversation to look, listen, number one, let's be safe. Don't reach. He was 100% cooperative. Did everything I asked him to do, provided ID, surrendered the firearm exactly as I ordered, was completely compliant. I remember the firearm being a Glock 9mm in a holster that was in his right side waistband.
In that, when you pulled up, that was completely concealed. He had removed that.
Yes, it was. I remember him wearing a black t-shirt that was untucked and black jeans, and the holster was the firearm was inside a holster, Judge, and the holster had I remember having a clip on it, and the clip was essentially clipped to the waistband of his jeans to hold the holster and the firearm inside of his jeans.
Thank you. And do you see the individual that that had removed that firearm from himself in the courtroom today?
Yes. He didn't remove it. I removed it,
Oh, okay.
but he was compliant completely with my
Understood,
direction. Yes.
understood. Do you see the individual that you removed the firearm from?
Yes.
Can you identify something that he is wearing?
Yes, seated to my left, wearing a black polo style shirt.
Your Honor, I would ask that the record reflect that the officer identified the defendant.
Any objection to the witness identifying the defendant for purposes of prelim?
No,
For purposes of prelim, the witness has identified the defendant.
And just to clarify, you at that point, you had already asked him, he stated he did not have a CPL.
Yes, and that was further validated when I got out and engaged him in the follow-up conversation, and was clear to me in the beginning and then verified with the follow-up conversation on foot that he did not have a CPL and that he was holding the firearm for his girlfriend who was nearby, who was on scene and did have a CPL.
I have no further questions at this time.
Thank you, counsel. Cross-examination, Mr. Abbott.
thank you. Good morning.
My sir.
So you stated that one of the first signs that started to draw your attention from your observation to suspicion was his anxious attitude.
I don't remember anything about his attitude. I remember seeing his behavior
His anxious
change to
behavior?
be anxious upon seeing me.
Okay, and you were in a fully marked police car,
Yes,
wearing a police uniform.
yes.
Is that sometimes all it takes to make people change their behavior? Just to see a police officer?
I would agree. It could be situational. There certainly could have been other issues that he was concerned about seeing me, of course.
All right, so, and you testified that the firearm was on the right side of his
Yes,
body?
yes.
And so when you approached him, he was facing you? Looking at you?
I'm sorry. I didn't
When you
hear
were
that.
driving towards him at first, was he looking at you, like right at you?
I remember making eye contact with him pulling up, and he was essentially looking right at
And how far away would you say you guys were apart? How far apart?
me. I would approximate the first time that I saw him and understand that I was moving in my patrol vehicle, driving slowly through the parking lot. I first saw them probably, I would say maybe 100 feet away. And I pulled up directly next to him and engaged in conversation from less than 20 feet.
Okay. And as you approached him, did he turn his right side away from you?
He did yes, he did at one point.
And was that when he walked over to the picnic table and sat down?
I don't remember that. I remember him seeing me being nervous, turning, and just his behavior completely changed. And turning was part of my observations of him being anxious.
And so anxious behavior, turning, and a retention touch. So he's just putting his hand down there? Is that what you're saying?
Yes, and then he also, I remember his pants were sagging down, and I remember him
Can I stop you
adjusting
right
his
there?
pants.
Before you go any further, sagging down pants, isn't that a pretty common sight? A lot of people wear their pants sagging down.
Yes, I would agree. The difference the important piece here is it is in combination with all the other factors of the behavior change.
So when he made one retention touch?
No, I remember him making several.
And is this as he's walking towards the picnic table?
Yes,
And at this time, you hadn't actually seen a gun,
no, that's true.
and all you saw was an outline, a bulge in the t-shirt.
Well, yes, I absolutely saw a bulge protruding through his t-shirt. That is true.
And you were, based on your training and experience, thinking that was probably a gun.
I was convinced it was a firearm, and that's why I followed up.
And his girlfriend had a CPL,
That is true.
and he said that he admitted to you that she had just given it to him.
Yes, that was his initial statement. Is we were on foot together initially, essentially first contact.
So you're on foot together. He got up from the picnic table.
I'm sorry, what
When you
point, sir?
well, so he's sitting at the picnic table, and you got out of the car
Yes,
and you walked towards him.
yes,
Did he stand up?
yes,
Okay. And then you had your conversation with him.
yes.
Then during that conversation, he admitted that he had a firearm.
Yes.
I have no further questions.
Thank you. Mr. Marshall, any redirect?
No, Your Honor.
May this witness be excused from the people,
Yes, Your Honor.
from the defense?
Yes, Your Honor.
Right, thank you. You're excused.
Thank you, Judge.
Any further witnesses, Mr. Marshall?
No, Your Honor.
Do the people rest at this time?
Yes.
Mr. Abbott, any proofs today?
No, not today, Your Honor.
All right. Motion for bind over, Mr. Marshall.
Your Honor, the people feel that we have met our burden of proof for bind over in this matter. Officer Forbes testified that to the ID and proper venue in this matter, that on this date, while on patrol, he observed what he described as several retention touches while observing the defendant walking, a bulge that he believed to be a firearm, along with the fact that the defendant's demeanor completely changed and started acting nervous. At that point, he approached the defendant, not even out of his vehicle, and just had a conversation. He asked the defendant if he had a CPL, to which he denied. The defendant admitted to having a gun, and that gun was removed from the inside of his waistband. I believe he testified to the right side. The fact that he does not have a CPL and that was completely concealed would meet the elements of this crime. And that he also testified that it was a black Glock 9mm pistol.
Response to motion for bind over, Mr. Abbott.
Thank you, Your Honor. It seems like a Terry stop analysis. Whether or not the officer was able to articulate a reasonable suspicion. Well, based on the fact that these people didn't know each other, and he seemed, after just moments of observation, decided that he had just become anxious and just become nervous. Seems a little incredible, Your Honor, since he may have been nervous and anxious all morning. In addition, Your Honor, he admitted that he couldn't actually tell what was in the waistband, only that it, was on his right waistband and it was a bulge. There's nothing specifically suspicious about having a bulge under your t-shirt. So I'd ask the court to consider the reasonableness of the suspicion that was articulated by the officer in its analysis. Thank you.
Thank you. Probable cause is any response, Mr. Marshall?
No, Your Honor.
Probable cause is the standard for preliminary examination. Probable cause being the second lowest standard in criminal law. Reasonable suspicion, which is the Terry standard, is the lowest suspicion, but we do have on or about May 7th, 2023, the venue of the city of Lansing, location at 102 West Randolph Park, have been met by probable cause evidence and testimony of Officer Rob Forbes from the Lansing Police Department. He made identification of the defendant, Mr. Trainer, for purposes. And so this does come down to what initially just was a patrol car incident on Randolph, driving by St. Therese in the city of Lansing. And then as he gets approached, he sees some behavior which would indicate that Mr. Trainer is not acting the way somebody. Well, regardless, Mr. Trainer does a retention touch and then moves, and Officer Forbes is moving towards him. I think he described the feet, the complete feet started 100 feet and then got less than 20 feet. At some time, that investigation or that suspicion changes as he sees a bulge in the right side, which the officer, based on the retention touches that he did observe, took to mean that there may be a gun present, which changes the reasonable suspicion. And so he makes inquiry of it by approaching and indicating the question as to whether he had a CPL or not. And Mr. Trainer immediately indicates that his girlfriend has a trainer. His girlfriend has a CPL. Part of the rules of having a CPL, as the court's aware of, is that the person holding the gun is supposed to make it aware to law enforcement immediately. That being aside, Mr. Trainer indicates that he does not have a CPL. His girlfriend has a CPL. He obviously is carrying the firearm, which is provided to him with 100% cooperation, as the officer testified. The Glock 9mm. It's in a inside waistband holster carrying mechanism. So although it was his girlfriend who had the CPL, he has a carrying mechanism for the Glock 9mm on his person in his waistband. And therefore, I believe that the Terry stop and Terry reasonable suspicion is met, and then the defendant indicates that he has a weapon, he does not have a CPL, and it's concealed on his person. I believe that the prosecutor's proven by probable cause evidence of the offense elements of carrying a concealed weapon, in that Mr. Trainer did carry a dangerous weapon, to wit, a Glock 9mm or pistol on or about his person, contrary to the law of the state of Michigan. And I will grant the motion to bind over. So I grant the motion to bind over as charged. So, Mr. Trainer, your time in district court is now done. You'll be on to circuit court, which is the trial court on the felony matter. The court has found probable cause evidence to bind over. You should receive any new date from your attorney, Mr. Abbott, concerning this file. Anything else for the record, Mr. Marshall, on 23-02-140?
No, Your Honor.
Mr. Abbott.
Not from the defense, thank you.
All right, Mr. Trainer, please keep in contact with your attorney, Mr. Abbott. He'll provide you with any additional date concerning this file. Your time in district court is all set. Okay, sir? All right, thank you.